Hi, this is Jeanette from Law for Your Website. Welcome to this week's blog. You might recall that last week we talked about intellectual property. Well, this week we're going to talk about copyright protection and what it is. You might recall that intellectual property is the collective term for different types of legal protection available for something that has been created. Copyright protection is a form of that legal protection available for created works. Different things can be protected by copyright, and copyright involves a bundle of rights. That's why you'll probably see on a number of web pages and different books and things that there's a comment, all rights reserved, written on it. That's because if you use a book, for an example, there is copyright in the actual words of the book. There's copyright in the typesetting and the way that it's presented. There's copyright in somebody reading the book out loud or turning it into a play. There's copyright in adapting that work to make it into a movie. So it's a whole bundle of rights. It's not just one right. Copyright is only a form of protection available for works, not for ideas. So if you have a fantastic idea for a new television program and you go and present that to somebody, you're looking at a different form of protection, not copyright protection. Copyright's not going to help you. The work to be protected by copyright has to be sufficient to be considered a creative work. So the title for a book or a movie is usually not long enough to attract copyright protection. However, there have been cases in the past where somebody has painted a blank canvas white and called it a particular thing, and that has been considered sufficient to give it copyright protection. Copyright copyright is a right attracted to written works, artistic works, including sculpture, musical works, dramatic works, and architectural works. So it's all those sort of creative things that you can do. You can protect a derived work or a compiled work. So a derived work is similar to the adaptation of a book into a movie, and the screenplay for the movie will be considered a derived work from the original book. A compilation or a compiled work is, for example, the complete works of Shakespeare. When Shakespeare was around, or if he was around today rather, copyright would attract to each one of his plays, his sonnets and so on separately, and it would also be attached to his works as a collective volume. So if you go and collect the works of a number of people into a book, then you can get copyright protection for that book, although the authors will probably still own copyright in their original works that they've contributed to that book. I'm going through this fairly quickly, and I'm looking at it from a really simplistic viewpoint. So you've got to remember that if you are actually creating something and you want to protect it, or you want to take action to use your copyright in a particular way, you do need to go and get specific advice. These are some really basic ideas and facts about copyright, just to help you get an understanding of what it means when you talk about getting copyright protection. Now, one thing we really need to clear up is that copyright's not the same as plagiarism. Plagiarism is a failure to acknowledge the source of an idea. You can extract a couple of sentences from an academic paper and put them in your work without breaching copyright, provided that the academic paper is, 10 pages long, because you're not taking a substantial piece of that work. However, if you try and submit that as part of a university assignment, you're going to get into trouble if you don't acknowledge where you got those words from. So plagiarism is the failure to acknowledge the source of an idea or a comment or writing, and copyright is actually a protection for creative works. So they're two different things. Now, what can you get copyright protection for? Copyright protection is protection against having other people copy your works, publish them, distribute them, and it usually involves some sort of impact on your earnings from that, from what you're seeking to protect. So it's not just about reputation. It's not just about wanting to keep something secret. It's usually, if you want to take it to a court and you want to protect it in that way, it usually has an impact on your ability to earn from that work. To get copyright protection, you've got to demonstrate that there has been substantial copying. Now, what is substantial is a very loose term, and it's subject to interpretation depending on the work and the court that you're in. A lot of people, for some reason, use 10% as a guide. If you do, it is a guide only. Just because you only copied 10% or less of a particular book, for example, doesn't mean that you won't be found in breach of copyright. Because copyright, it could still be just a small but a very significant part of the works. If you look at music, or you consider music, look at Sweet Home Alabama. That has the same riff as Werewolf of London, and it's been used again recently. That riff that is highly identifiable as soon as it's played is a significant part of that musical work. And because it's a significant part, even though it represents less than 10%, I think it's only one bar of music, it can still attract copyright protection because it's so recognizable and so significant. Okay, so that's a really quick run through of copyright, what it is, and what copyright protects. So next week, what we'll have a look at is who owns copyright.